What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta, owner of Rekieta Law, a small law firm in central Minnesota, and I make YouTube content talking about random lawsuits and other legal topics. Today, this is a summary video of a much longer video that I have done for the lawsuit between Mars Argo and That Poppy, as well as Mars Argo and Poppy's former and current producer, respectively, Titanic Sinclair. So, the claims in this are copyright infringement, common law right of publicity, violation of California's unfair business laws, and domestic violence damages. This video is a very short summary of what those claims mean and what my opinion of them are. And if you want a full breakdown, please check the section below, the description below, and I'll have a link to my full video. It's about an hour and a half, and it goes through every single line of those lawsuits. So if you want to consume the lawsuit's content and you want to know what's going on specifically in relation to the claims, please watch that video. If you just want a quick summary of what the claims are and what my opinion is on the validity of this claim, here's this video. And if you think other people are interested in that, please like it and share it all over the place. I would love you very much for it. And if you're new to this channel, seeing this stuff for the first time, please subscribe. I cover all sorts of lawsuits and talk about the legal aspects of them and give kind of my opinion on what's out there. So the first claim is for copyright infringement. So going through this whole complaint, which is 44 pages long, Argo basically says that Sinclair and Poppy have copied her aesthetic, her style, her, I guess, the whole look about the content that she created in the past. There are severe problems with this claim. Okay, first of all, you don't get to copyright your persona, who you are, your identity. Those are intrinsic things that you didn't create. Those are copywritten, even though it may seem like you create them because you may have developed a style or you embody this sort of personality. Those are not actually your creative work. You can own a copyright in recordings of that work, right? Like you create a character or a persona and then you record that in some sort of medium. In this case, like a music video or photographs. You can certainly own a copyright in the music video and those photographs. And then if other work is derivative of those things that you own a copyright in, then you can say it's derivative and you can collect. In this case, or one more point of order on copyright, sorry. You can't own stuff that you didn't create. So if you're borrowing from a culture or a particular artistic style, if you're borrowing from someone else, you don't own what you borrow. You only own what you change after you borrow it. In this case, it looks like Argo is borrowing from something she specifically references in the complaint, which is kawaii culture, which is described in the complaint as cute Japanese culture. If she's borrowing from cute Japanese culture and Poppy is also borrowing from that same cute Japanese culture, then Argo doesn't own that. And there is no copyright because there is no ownership. Even if Poppy is deliberately copying Argo's style, but that style is borrowed from somewhere else, Argo doesn't own it. Poppy can copy it because Argo was copying it. And if you go through and start to look at some of these things, you find real problems with the idea of ownership because Argo's work looks derivative of sort of retro looks from the late 70s, early 80s, and then the late 90s, early 2000s in different places. And so does Poppy's. And so if those cultures just happen to be overlapping and they're borrowing from the same source material, then Poppy can certainly claim that her work is derivative of source material, not derivative of Argo's work. I think the copyright infringement claim fails. The best evidence that she has is the claim that Poppy copied some specific lines and editing styles in one of the videos that's mentioned in the longer thing. But even that I think is a pretty weak claim. And I'm only basing it based on this complaint, which is going to be obviously biased towards Sheets or Mars Argo. And I think that even that, which is the strongest claim, is still a weak claim, in my opinion. So next is the common law right of publicity. This is the right not to have your image used in endorsing a product. So like if you put Arnold Schwarzenegger on a brand of protein powder, like you're going to think that it's an Arnold Schwarzenegger endorsed product. So you better have Arnold's permission to use that. That's the claim here. This is a really weak claim. Argo is claiming that Sinclair and Poppy are using Argo's likeness to promote their product. But at the same time, she's claiming that Sinclair and Poppy prevent Mars Argo from even being mentioned on any of their social media accounts, and it's a blocked phrase on YouTube. If that's the case, it doesn't look like they're trying to use Mars Argo to promote their product. It looks like they're trying to distance themselves from Mars Argo and create a distinct brand. I think this claim fails because it's just not very good. California's unfair business laws, basically if claim 1 or 2 are valid, then automatically claim 3 is valid. Since I think 1 and 2 are invalid, I don't think claim 3 is valid. This basically says if you're violating the law to gain a business advantage, that's unfair, and you get recovery under California law. Note that this is brought in federal court, so award under federal court and California would be possible concurrently. Finally, the domestic violence damages. These sound like real claims if we take them at face value, but the problem is they're all 3 years old, roughly, and the statute of limitations in California for abuse and violence is 2 years, and I believe that extends to domestic violence damages as well. So I don't think, unfortunately, because it sounds really awful, and if it's true, you know, Sheets certainly has lots of reasons to dislike Mixter, who appears to be an unstable and horrible human being in some ways, and that may be true, but unfortunately, all of these actions happened in 2015 or earlier. That means they're beyond the 2-year statute of limitations, and that claim should fail as well. So all in all, I think this lawsuit fails. I'll be anxious to see the response from Mixter and Pereira, Sinclair and Poppy, respectively. I think they will respond separately because they have 2 separate brands that they're both individual owners of, but we will see. If there is a response filed that I have access to, I will gladly cover it on this channel. Thank you so much for watching. This is just a short summary video, and if you're interested to see why I think the things I think, definitely check out the longer video, which again is about an hour and a half, and I go line by line through everything in the document so you can get the full story as relayed in the light most favorable to Sheets or Mars Argo, which is kind of a sad thing because in the light most favorable to her, I still think she loses. Anyway, thank you for watching. If you're new to the channel, hit like, subscribe, hit the notification button. If you want to see specific content, hit me up on the various social media platforms listed below. Again, if you know people who are fans of Argo or Poppy and want to kind of get an idea about what this suit is about, share this video and the other video with them and let them see it. Thanks a bunch for watching, and have a great day. Peace.